Doxing someone isn't free speech. Advocating criminality isn't free speech. Let's talk about that. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. A few days ago, I did a video on how stupid it is to vandalize Teslas, and I pointed out the costs not only to the victim, but to society at large and to the criminal actor as well. Now, I've said before that I believe strongly in the First Amendment. It protects free expression. But like all rights, it's not absolute. The law recognizes that making threats and to put people in fear of violence is not free speech. The law recognizes that you can incite a riot and that that is not free speech. The line between free speech and criminality when advocating violence is a nuanced area of law that balances the First Amendment rights with the need to maintain public order and safety. In the United States, that line is primarily defined by court rulings, particularly the landmark decision in Brandenburg versus Ohio, a 1969 Supreme Court case. Here is how it generally works. The Brandenburg versus Ohio case established a two-pronged test to determine when advocacy of violence crosses the line into criminality. First, the speech must be directed to inciting or producing imminent lawless action. This means that the advocated violence must be intended to happen soon after the speech is made, not at some indefinite future time. Now, of course, at the time, you were talking about speech being done like when you were talking to someone at that point in time or you're addressing a crowd. But if you put something on a website where people can see it any day, that also is speech. It's also protected free expression as long as it doesn't direct people to incite lawless action. The speech must be likely to incite or produce lawless action, and that means there must be a real possibility that the speech will lead to violence or unlawful conduct. Intent. The speaker must intend for their words to result in lawless action, not merely express a desire or an abstract idea that violence might occur. It might be okay to say, well, I certainly think that anybody that buys a Tesla right now should get punched in the nose. That's different than saying, this is where you can find somebody who's going to buy a Tesla and punch them in the nose. Or you should punch people in the nose, period. There's no ifs, ands, or buts about it. Basically, you have to express an intent that violence occur. Now, context matters. The context of the speech is crucial. Context includes the speaker's tone, the audience's disposition, and the setting of the speech, whether any preparatory steps have been taken to act on that speech. For example, if people brought, you know, torches and pitchforks to a meeting, you might, sort of figure out that they were of a mood to get violent. And if you said things to incite them, again, the context would be pretty clear. Clear and present danger. This concept, although refined by Brandenburg, still underlies the assessment. There must be a clear and present danger that the speech will lead to violence. So, direct calls for immediate violence. If someone explicitly instructs a group to attack a specific target immediately, this would likely meet the criteria for incitement. Coordinated plans of action, speech that involves planning or preparing for violent action, especially with steps already taken to execute the plan, is more likely to be viewed as incitement. And you have to realize that abstract advocacy or statements just expressing support for violence are protected. Hypotheticals and artistic expression. Discussions or expressions in art or hypothetical scenarios that don't direct or encourage violence also are protected. The balance between free speech and preventing violence is delicate, and courts often have a difficult time with it. The First Amendment protects a wide range of expression, but when speech is aimed at inciting imminent and likely violence, it crosses into criminality. And that brings me to a website by the name of Dogequest. That website doxes Tesla owners, and surprisingly, it also doxes the director of the FBI, which, again, is sort of like waving a red flag in front of a bull. I'm not going to show you the website, but the website encourages visitors to commit vandalism, including by using a spray paint can to unleash their artistic flair. And they direct that to nearby Tesla dealerships and people who own Teslas and say, hey, this is a creative way to express your protest. And in a reference to the escalating vandalism of Tesla vehicles on facilities in recent weeks, the cursor on the desktop version of the map is an image of a Molotov cocktail. Okay, doesn't that meet all of the tests we just talked about? Intent, incitement to violence, clear and present danger. I mean, Paul Kim in Las Vegas allegedly torched a Tesla dealership, and he did it with a Molotov cocktail. I mean, there is just too much there. This is dangerous, and the person involved in setting up and maintaining that website could be in for a world of trouble. That means we have to think about a lot of things here. First of all, criminal conspiracy, as well as aiding and abetting. Those are both potential charges. So if somebody uses information from that website, finds a Tesla, destroys it, then the people who set up that website are definitely aiding and abetting this criminal conspiracy, and they could go down for it. In addition, in many states, the individual owners have a right to sue for damages under privacy laws, even if their Tesla is not damaged. The tort of publication of private facts is a legal claim that a person can make if someone publicly shares private information about them without permission, causing embarrassment or distress. Here's a breakdown of what that means. Private information. The information must be fully private. It means that something's not already known to the public or easily accessible. And here, it is the tying of the Tesla to the address. The address is public information. You can get that a lot of places. To the Tesla. It's tying those two together that creates this publication of private facts. And in this case, I believe a court would consider the addresses and phone numbers of Tesla owners to be private facts because the facts are likely to be linked to a specific call to criminally damaged property. The information has to be shared with the public or a large group of people, not just a small group or in a private conversation. And it has to be offensive to a reasonable person. The shared information must be something that would be offensive and embarrassing, or embarrassing, I should say, to a reasonable person. This means most people would agree that it's not something that should be shared without permission. I think a judge and a jury would both find that sharing the location of a Tesla with a specific intent to get that vehicle damaged would be offensive to most people, or at least most people who owned a Tesla. The information should not be of a legitimate public concern or newsworthy. There are all kinds of ways that this particular tort can be activated, but in this particular instance with this DogeQuest website, I believe they are probably coming really, really close to a line here. They may not be sued in every state because not every state has this tort. New York, for example, doesn't have this tort. But again, there is something called civil conspiracy, and if somebody's vehicle is damaged, then again, if the person who damaged the vehicle doesn't have the money to pay, the person who operates that website could certainly be sued under a theory of civil conspiracy. The tort is part of a privacy law that helps protect individuals from having their personal lives exposed, and it's evolved over time, and it changes pretty much, every year as these rules develop through the common law. The right of privacy is enforced through four particular claims. One of them is intrusion into solitude. The other is appropriation of name or likeness, also known as misappropriation of likeness. False light, and then this one, the public disclosure of private facts. For example, a 70-year-old man who owns a Tesla might choose not to reveal his ownership by garaging his vehicle. So if you drove by his house, you wouldn't see his Tesla. But if you knew that his Tesla was in there, maybe instead of firebombing his Tesla, you just throw a Molotov cocktail into the garage. So again, publishing that information, that confidential information made public, could very well cause him to suffer mistreatment and professional difficulties. Understanding that type of invasion of privacy helps understand the publication of private facts could cause significant harm. In addition to this tort, it's possible, even likely, that two or more people join together like I said, could be a civil RICO conspiracy. Now, RICO is the Racketeer Influenced Corrupt Organizations Act, and it's often thought of as a criminal act. Indeed, that's one of the things that Donald Trump was charged with for his election interference enterprise in Georgia. But the claim allows individuals to sue for damages, not just go after people criminally. And basically, when they've been harmed by a pattern of racketeering activity, they can sue for civil damages. And they have to establish key elements. First of all, they have to establish conduct. The defendant must have conducted or participated in the conduct of the enterprise's affairs. So, anybody who helped put information on that website, again, that's conduct. Enterprise. There must be an enterprise, which can be any individual, partnership, corporation, association, or other legal entity, and it can also be a group of individuals associated in fact, although not a legal entity. The enterprise must be distinct from the pattern of racketeering activity. And the pattern of racketeering activity is basically the commission of certain criminal acts, fraud, embezzlement, bribery, or other specified crimes. A pattern requires the acts to be related and amount to or pose a threat to continued criminal activity. The predicate acts must qualify as racketeering activity under the RICO statute. Common examples include mail and wire fraud, and of course, there's going to be a claim here that the use of the wires, the internet, is a portion of this, and that it was put out there specifically to encourage criminality. It may or may not fly, but again, it's sure going to require somebody to come in and provide a defense. And then injury to business or property. The plaintiff has to demonstrate that they've been legally damaged. And I think that's going to be pretty clear if your Tesla gets burned up. The statutory basis, in case you're interested, is 18 United States Code sections 1961 through 1968. They provide the basis for individuals seeking treble damages. So if your Tesla was worth $30,000 and it got burned to the ground, you could recover $90,000 under that statute and attorney's fees on top of it if you were successful. There are a lot of challenges in proving a civil RICO claim. They're very complex. They can involve a lot of evidence. The evidence has to be clear, it has to be convincing, it has to get past a judge first and then to a jury. Courts require detailed allegations, especially concerning the predicate acts and their connection to the enterprise. And the plaintiffs have to have standing, meaning they can demonstrate a direct injury to their business or property caused by the racketeering activities. Civil RICO claims are powerful tools that these people could use, and the folks who engage in a combination of doxing and advocating criminal acts against others could find themselves in some very expensive situations, in addition to the possibility of criminal prosecution brought by state or federal governments. So that's what I have for you today. I thought people would be interested in that the publication of private facts because, again, that's not something that you hear a lot about, but it is a viable claim in many states. And also civil RICO. Most people think of RICO as a criminal statute, which it certainly is, but it's also a civil statute that allows you to sue for civil damages. And again, if you are successful, you will get treble damages. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.